So a very, very good afternoon to everybody that's joined us this afternoon. This is part of our webinar series that we're running this year, and we're looking at farmer and land manager collaboration for environmental delivery. And I'm very pleased that we have Charles Russell Speechlys, who've been doing a lot of work for us on this. We have two excellent speakers who I'll introduce a little bit later. But just to set the scene, if I may, fortunately, despite recent political changes, the government remains committed to nature recovery and climate action. This is good news as it offers opportunities for farmers and landowners to access alternative income streams for environmental delivery, whether it's from government schemes or private environmental markets. The nature of nature recovery itself and the emerging funding opportunities means that buyers are looking for larger scale projects, and whether this is through a government ELM landscape recovery scheme in England or through private sector funding. In contrast, for a range of reasons, farmers and land managers may not be keen to commit large areas of land. So as a result, there's been a growing interest in collaboration between farmers and land managers to upskill and join forces to access this emerging market. Now, there are a number of options for collaboration for environmental delivery, and the purpose of this webinar is to shine a light on the benefits and opportunities, consider the pros and cons of different legal structures, and the associated risks. And with this in mind, as I mentioned earlier, the CLA has partnered with Charles Russell Speechlys, a firm of solicitors, to support our policy team on the legal issues of collaboration. Now, if we move to the agenda slide, what we will hear is we'll initially hear from Susan Twining, who is our Chief Land Use Policy Advisor, on what is driving interest in this collaboration, before we hand over to Edward Robinson and Tristram van Lowick from CRS, who will investigate the options and then the pros and cons of different legal structures. Now, there is a Q&A box at the bottom of your webinar slide, and following the presentations, you'll get an opportunity to ask some questions. So do use the Q&A button on the Zoom button at the bottom, and we'll come to it towards the end. Now, Susan Twining, who's our Chief Land Use Policy Advisor, has fortunately been with us at the CLA for a number of years and is highly focused on policy across agriculture, forestry, and the environment. And I'm going to hand straight over to Susan to give her presentation. Thank you.
Thank you, Mark, and good afternoon, everyone. I just wanted to firstly have a look at what's driving these changes, and clearly the changes in agricultural policy towards payment for public goods and the environmental targets being set in the Environment Act 2021 is one of the key drivers, and it's increasing both public and private funding in environmental delivery. The new environmental land management schemes in England are the basis of the government funding for the future, while the private sector environmental markets are becoming more established for nature-based projects, following years of pilot projects, which many of you may have been involved in. The key markets that are developing now are firstly the voluntary carbon market is perhaps the most established, but others which are driven by legislation and regulations such as biodiversity net gain and nutrient offsetting are maybe are geared ready to start in the next few years. So it can be difficult to know what action to take, but it's clear that collaborating with other land managers is one of the strategies which can help businesses of all sizes take advantage of these future opportunities. If we look at the benefits now, Collaboration has many potential benefits. As Mark said, it's not the UK is not always been recognised for its willingness to collaborate with other businesses, but it does offer the chance to learn from others within the sector, to share experiences with those who may be facing similar set of challenges, and to take advantages of economic opportunities, especially those arising from economies of scale, whether that's in terms of accessing goods or services or in terms of supplying them. And it also enables joint marketing and a single point of contact in some cases that makes it easier for the market to access you and for you to access the market. If we look at collaboration in practice, I think it's fair to say collaboration is not new. There is this stubborn view that UK farmers don't work together, but that depends on how it is defined. There are increasing numbers of formal and informal arrangements that allow farmers and land managers to work together, share costs and drive opportunities, whether that's environmental markets or indeed for farming and forestry. So with collaboration, it could be as simple as two neighbours working together or a landlord and tenants. But when it comes to environment, there are increasing numbers of farmer clusters, often supported by funding from the Countryside Stewardship Facilitation Fund, while others might be self-funded or have sponsorship. But these farmer clusters come together initially often to share best practice on environmental management. And many are now expanding their focus to access new funding streams and to access these emerging opportunities of the large-scale environmental delivery. So key to success of these groups is having the right agreements in place. And this is the focus of the next part of this webinar. I'll now hand back to Mark to introduce the next speakers.
Susan, thank you very much indeed. We're extremely lucky this afternoon that we've got two lawyers from Charles Russell Speechlys who specialise in this area. We've got Tristram, who's a private property lawyer, and Edward Robinson, who specialise in corporate structures. And you can see their profile on the slide, and I'd like to hand directly across to them. So over to you, Tristram and Edward.
Thank you very much, Mark. So Susan has talked to you about the why you would want to collaborate with other landowners, other businesses. Edward and I are now going to look at the what and the how. What are the options for the different structures, and how do you go about setting them up and running them? As Susan alluded to, I think it's fairly safe to say that collaboration is a fairly familiar concept in the agricultural world, from the sort of smallest family farming partnership, through to livestock markets, abattoirs, etc., that are owned and run for multiple stakeholders across the entire farming community. So many of the structures that we're going to look at and talk about will probably be familiar to the majority of you, albeit you may know them with different names or in different guises. The key difference is the context in which those structures are operated. Most of the joint venture agreements that we deal with and set up for clients, for farming clients and landowning clients, CFAs, share farming agreements, family farming partnerships, tend to be set up to be run by and for a small number of closely connected individuals. Where third parties are involved, the agreements, the structures tend to be quite short term and with the ability to bring them to an end. In the circumstances that we're considering now, we're talking about collaboration that's likely to be on a much larger scale in terms of number of third party involvement, and also the duration of the agreement. Looking at BNG, talking about potentially committing to something for 30 odd years. So with that in mind, we're going to look at some what will probably be fairly familiar structures, but looking at them in a slightly different light. Now, before we go on to look at the different structures, there will be a number of points you need to consider before deciding on which is the right structure for the venture you want to follow. A number of these are set out on the slide here, so considering what the objectives are of the structure, whether you're interested in capital growth or generating profit, how many parties and the term we've discussed. Very importantly, though, is the last point, and that's tax. Tax will be very important points to consider, because whatever structure you enter into, there will be tax consequences. And those consequences could be the deciding factor for which structure you follow, or at very least it will bear a huge influence on which decision you make. I'm not a tax lawyer and we don't have time to go through all the tax implications, but just picking up on some key points that will need to be taken into account by you, your tax advisors. Firstly, what the implications are of or tax implications on entering into the structure if you're putting anything into the structure, any capital, for instance. What are the tax implications if you're taking anything out of the structure, whether that's through profit or withdrawing capital. And thirdly, and very importantly, is what impact will the structure have on your IHT planning? Will entering into this new structure be of benefit for your succession planning, or will it require additional work behind the scenes to ensure that the eventual ownership structure behind your new collaborative structure is as tax efficient and ties in with your proposed succession planning? So bearing all this in mind, Edward will now look at the different structures that are available to you. I've already mentioned two specific examples of collaboration through CFA and share farming, which, as Edward will now explain, are a form of contractual collaboration.
Thank you, Tristan. Thank you. So a collaboration by contract is exactly what you think it is. This is where the collaboration, the structure, is purely a contractual document. And in the corporate world, we see a lot of this. We see a lot of corporate collaborations through contract. I'm going to give you an absurd but simple example. Let us take Mr. Joe Bloggs. He has a chocolate factory. His good friend, John Smith, has a teapot manufacturing facility. They decide late one evening that it would be an excellent idea if they were to set up a range of chocolate teacups. They decide that neither of them wants to give up their current operations, but what they would like to do is come together by way of agreement and decide how they're going to proceed. In this circumstance, one provides the chocolate, the other provides the teapot molds and the staff. The first provides the bank account and the distribution chain. So together they write an agreement that dictates what each of them is putting in, the risk and reward to each of them, how the profits are going to be divided, and underneath that contractual matrix, they then each go on and operate in the usual way, but with that overarching framework. And in that particular example, one of them would use their bank account and would be the party dealing with third-party wholesalers, or as the case may be. So that's a really super simple example of how that might work. The key virtue of a collaboration by contract is that there is no continuing administrative burden, by which I mean, if you've just got a contract with somebody, you don't need to register it somewhere, you don't need to file forms annually, you don't need to report to anybody else. It's just a contract. There's no administration to it other than that the parties have to have regard to it during the life of the contract. The big downside of a collaboration by contract is that we don't have any separate entity in the structure that limits the legal liabilities of the parties. So to take our hypothetical example, if the teapot molds were not properly cleaned, such that there was contamination and food poisoning by the ultimate end user, then Joe Bloggs, our chocolate magnate, might find that he's personally sued by some of the end users who's suffering from food poisoning. And he would be directly liable for those losses in the usual way. And his only remedy would be a contractual remedy under this framework agreement with the teapot manufacturer. But that's a level removed. And if the teapot manufacturer is insolvent, or if there's some contractual agreement that they would bear that loss, that is something that is borne directly and personally. So collaboration by contract, I mean, it certainly has its uses, but when we will come to the subsequent examples of corporate structures where there's a limited liability, you'll find that's a situation where the individuals involved are not personally exposing themselves to risk and liability. So it has its place. I think another really important thing to say about collaboration by contract is that it tends not to be as easily scalable. To take our, again, ridiculous example, if they decided, these two good friends, that they wanted to enter into they want to bring in a third party, Mr. PG Tips, who wants to sell some tea bags to go in with a product. what that would probably look like is that they would have to tear up their original contract and write a new one almost afresh to reflect the new division of risks, responsibility and reward between those parties. So the virtue of the contracts is that they can be incredibly bespoke. They can be tailored to the exact position, split risk, reward, opportunity, growth in any way the parties want. But that same flexibility in the immediate situation, that bespoke contract tends to leave it less suitable for situations where you've got members entering and leaving, because in any contractual arrangement, the underlying scenario can only be amended with the consent of all parties. So it's amazingly flexible going in, but can be difficult to change. So where we tend to see these contractual collaborations and where they work really well is if you've got a small number of parties, each with a very defined mandate for the work that they're going to be carrying out, and the contract can perfectly divide up the responsibilities, how it's going to be apportioned, how the reward will be split, and there it works really well. But for very long-term situations where there's likely to be a turnover of individuals, they perhaps don't work quite as well. So I think that was all I had to say. I don't know, Tristan, if you had anything else to...
Thanks. So contractual collaboration, once it's set up, is pretty rigid, doesn't offer a huge amount of protection and not really for the long term. So in the context of this, it doesn't sound like the best option. But now we're going to move on and look at a slightly more flexible collaborative vehicle in terms of day-to-day with the company limited by shares or guarantee.
Thank you, Tristan. Yes, so if we take the previous example, if instead of Joe Bloggs and John Smith deciding that they would do this by contract, they could incorporate a new limited liability company, Bloggs Smith Limited, and they would go away and they would set that up, incorporate it through the usual process at the company's house. The major virtue of a limited company, together with some of the other corporate options we'll come to that are of a similar vein, is that they are a separate legal entity. That is to say that they can contract and enter into obligations in their own name and in their own right, and they can assume the liabilities and responsibilities and keep, therefore, a gap between the individuals that are behind that company and the company itself. So those that are standing behind it are not personally liable for the performance of the company. So that's probably the key point. There are some slight negatives to having a company as opposed to a contractual arrangement. There's an administrative burden. In addition to having to incorporate the company through Company's House, there are annual returns, there are confirmation statements, there are accounts that need to be filed. Various actions that the company will do throughout its lifetime will require documents to be sent and lodged to Company's House. And there is a level of administration to that, depending on the volume of work that needs to be done. The company will have to keep its statutory books. So just to say that there is some work that is involved in this, and it should be factored into any corporate vehicle because it will be required. And companies are subject to regulation, subject to governance under the Companies Act. And I think what this really means is that perhaps more so than a contractual arrangement, if something is happening that's significant in the life of the company, you're likely to have to go off and seek advice. Whether it be a lawyer or an accountant will depend on the circumstances, but because it's so heavily regulated, unlike a contractual relationship where the parties can largely operate freely as they've contracted between themselves, for Companies Act, there is an extra level where you are likely to involve professionals, whether it's your accountant filing your annual accounts or a lawyer advising on a filing that you need to make when you're allotting new shares. Just to add that there are, although there is a sort of division between the shareholders and the company itself, and the shareholders are protected from the liability that the company might assume, if you are a director of a company, then there are circumstances, you do owe duties to that company, fiduciary duties, and there are circumstances where you may be personally liable if you fail to act in the best interests of the company. I can and have done talks that are in excess of an hour long on director responsibilities, so I won't be going into this in great detail. Suffice it to say that if you are setting up a corporate entity and you are personally going to be sitting on the board of directors, it's something that you'd want to take advice on at the time. What sort of things do you need to be mindful of when making decisions? What do you need to factor in? So one of the big benefits of a company, because it's a separate legal entity, there are some more options to raising finance. So because it's a company, it can issue shares. If it needs additional funding, and one of the best routes for that is additional equity, then you can get individuals that will come in and acquire shares, and that is a route that's not available under contractual collaboration. Because it's a separate entity, it can borrow debt in its own right. It can be a borrower, whether that's from a bank, whether it's from shareholders, whether it's from third-party private interests that want to come in and take a stake. And I suppose this is one of the big advantages from a contractual arrangement, which is it's much easier for a third party that might be interested in just contributing funding. They can just make a loan to a company. It's very straightforward. Whereas if they were to do it to a contractual arrangement, you then have to factor in how does that mirror with the other rights and obligations of the parties? What's the priority? How does that all fit together? Whereas in a company structure, because the liability sits with that entity, it does give a few more options around funding, around how the company can raise capital. And I suppose the final point that's on the slide here is that companies are very easily adaptable, in that the way you would typically structure a company is that it will have a governing document, what are known as the Memorandum and Articles of Association, that are the bylaws of the company. And those documents set out the rights and obligations of the shareholders to one another. If you have a new shareholder who comes in, they will just automatically be bound by those obligations. They're automatically taken as having to agree to those terms. So it's quite easy for a company structure to expand by saying we want to bring in another party, we're going to give them some shares, and automatically they're then within the overarching sphere. We don't necessarily need consent of all the existing shareholders, depending on your structure. So it's perhaps more so than a contractual obligation, a bit more flexible. And I suppose what I would say about that is this is probably one of the better long-term options. Companies have an indefinite life. They can run for as long as the parties want. And so for that reason, it is quite good for longer term structures. It also has a really useful dual ownership control structure, which is that it's owned and controlled by the shareholders, who are the ones that will benefit, who will have dividends declared to them, who participate in the capital growth, but it is run by its directors. The directors are responsible for the day-to-day management, and so it is an option, therefore, for parties to come in almost on a silent basis. They're not responsible for running it, but they get various benefits from being an owner. I think that was it. Tristan, I don't know if you had anything that you wanted to.
So company sounds like a brilliant vehicle for someone who wants to invest in or to collaborate and reap the rewards from that collaboration without necessarily having to get too involved in the day-to-day, while also having the protection of limited liability. But I think it's also worth just adding that there can be complications if you have put assets into a company and then subsequently want to take them out, potentially when your project has come to an end.
No, that's a really good point, Tristan. Yes, one of the potential difficulties with the company is that once you have contributed capital or assets, once you put something into a company, it can be very difficult to get it out, particularly in situations where the company isn't profitable and there aren't distributions that can be permitted. The part of the regulation around companies is such that it's not easy for shareholders to extract value unless there are appropriate profits that sit in the company. It can be done. There's processes around it. It takes a little bit of time, a little bit of effort. And so just something to be mindful of, because it is much, those assets are very much tied up. And so if that is going to be an issue, it would have to be something that we contemplated at the outset.
And now we're moving on to community interest companies, which quite interestingly, we've been approached by a few clients over the last few months, specifically asking us about community interest companies. with a view to environmental delivery. So it's quite opportune time to pick this up.
Yeah, no, thank you, Tristram. So some of you may be familiar with community interest companies, also known as CICs or KICs. You will, if you have ever come across one, you will recognise it because all KICs have to, as a matter of law, the company name will end in either KIC or community interest company, in the same way that a limited liability company has to end with limited or LTD or Welsh equivalents. So you would spot it immediately if you were ever involved in a deal where there was, or a transaction where there was a KIC. So the key element about a community interest company is this concept of community benefit. And what that means is it is a strict requirement, and you cannot incorporate a KIC unless you are able to demonstrate to Companies House to their satisfaction that you've met this criteria. But you have to be able to demonstrate that the primary benefit of the work that the KIC is doing is for the community, and specifically not the shareholders, not the directors, and not the employees. So to that extent, there is a real focus, and if you're not within that criteria, then it's not possible to become a KIC. It is very much a prerequisite. But if you are in that sphere, then this very much operates in a similar vein to companies that are limited by shares or guarantee, in that it's got a very similar structure. You've got the directors, you've got the shareholders. It's run in the same way, with the directors responsible for the day-to-day management and the shareholders responsible for key lifetime decisions. So in that respect, it is very much similar, and it is a limited liability company. So the individuals behind it are not personally liable. Now, as I said, there is this test, this community benefit test. If your objective is that there are going to be large numbers of profits, and the profit and the growth is all going to come out to the shareholders, this is probably not going to be an appropriate structure. It's probably not going to meet the community benefit test. And so if this is something you're thinking about, really at an early stage, you need to be thinking about how you're articulating that community interest, so they can be framed in such a way that when you get to incorporation, Companies House see it very readily set out for them that this meets all the criteria that they're looking for. But for some of you, this just won't be appropriate, and obviously then this isn't really a relevant point for you. KICs are governed by the Companies Act, so exactly the same regulation as you have for other companies, but there's also an additional level of regulation. So there's an obligation to produce an annual report, and that annual report has to include various things, including a report on how the KIC is doing on delivering the community benefit that was promised, whether there's any director pay, if there are monies or assets that have gone out at an undervalue, all the sorts of things that a third party might want to see to make sure that they're comfortable that this is actually delivering its community benefit. And so there is a sort of regulatory burden on it. And the way that I see this is that on the one hand, you might have, at the very far end of the scale, you have a limited liability company, and at the far end, you have a charity, and this sits along that line, probably partway down. It is regulated. It is not a charity. A KIC cannot be a charity, but it's heading on that way. You have to very much demonstrate your community interest. So why would you do this? Because as you will see, there seems to be a lot of additional burden here, a lot of additional obligations. It's a lot more difficult. Why are our clients interested in community interest companies? And the answer is that by associating yourself as a KIC, you are setting yourself out as, we are somebody that meets these criteria, we meet this community benefit, we have agreed to a structure that means that we can't extract value from this entity for our own benefit, we are for the benefit of the community. And third parties will realise that. They see you're a KIC, they know that you are held to a higher level of responsibility, and for those that are in that sphere, for whom this is an important point, it's a big selling point. It is your brand. We are a community interest company. This is it's not just a small selling point. It is a big selling point. This is what we are. So this is very much almost a vocational corporate entity, as it were. And so if you fit within this sphere, then setting yourself up as one just really advertises yourself to the world, to everybody that might be interested to participate in this entity, that this is how we're run, and that is a major selling point.
Thank you. And we're now moving on to a more familiar structure and potentially a less familiar structure in cooperatives and community benefit societies.
Thank you, Tristram. So for some of you, I mean, cooperative societies, I'm sure most of you have heard of. Community benefit societies, this was a bit of a rebranding back in 2014. The old industrial and provident societies, the government decided were sounded slightly archaic. So that's all been slightly rebranded as community benefit societies. So these are societies that are run for the benefit of their members, in the case of a cooperative society, or in the case of the community, for a community benefit society. And when you're incorporating either of these, you need to identify which of those it is, whether it's a cooperative society or a community benefit society. As with the KICs, this again is very much focused on wider benefit, and there are a lot of restrictions, a lot of regulation in this area, and a lot of restrictions on what can be done with profits, with growth. For a cooperative society, those have to be utilised for the benefits of the members and the membership as a whole. For a community benefit society, really it's focused on benefiting the community, and there's extremely little opportunity for assets and growth to be extracted to the members. So again, it's just a real initial consideration. If you're thinking of something being run for a profit, then this probably, in fact, almost certainly is not for you. These societies, they're slightly different to the corporate entities I've discussed before, in that they're regulated by a completely different entity. They're not governed by the Companies Act at all. They're governed by the Financial Conduct Authority, and indeed you have to go to them to incorporate. They are very specialised, these entities. We're very fortunate that we've got a team here. It's part of our charities team who work on cooperative and community benefit societies, because they are very much at that end of the spectrum. They are, and in fact, a community benefit society can be a charity as well. That is a permissible setup. So that's the scale. We are, say, very fortunate to have a team here, but they are very specialised. And if this is something that is of interest to you, we would just say something that's worth taking advice on at quite an early stage, because they are quite technical, and making sure that it's all structured in such a way that you're going to meet the criteria is just really, really helpful. But in other ways, very similar to the other discussions, they do a separate legal identity. The people that stand behind it are not personally liable. The next slide, and this is just a really short slide, just on joint ventures. This is just, sometimes you hear people talking about, I'm in a joint venture with this, I'm setting up a joint venture, and you might be thinking, well, what does that mean? If somebody says that I'm setting up a JV or a joint venture, how does that work? How does this fit into the structure? And the simple answer is that it's not really a legal term of art. Joint ventures tend to be either contractual joint ventures, as I discussed earlier, or limited liability companies. And you might have heard of somebody setting up a JV co, which is a joint venture co. It doesn't have any special meaning. So if somebody refers to, let's set up a joint venture, they can do almost any of these collaborative processes that we've touched on. But I just mentioned in case you think it's something different. It isn't. It's just part of the whole.
Nice. I think we're now moving on to our final structures, which are probably the ones that everyone's most familiar with our old friend, the General Partnership and the LLP.
Yes, thank you, Tristan. There is a reason that I've left this until the end, which is that our view is that this is probably not going to be the most appropriate for any sort of collaborative structure. But we wanted to cover it so that you knew that we hadn't overlooked it, and to explain why we tend to see that these aren't as appropriate. So the General Partnership, which I'm sure a great many of you are familiar with, it's a bit of a sticky one for us lawyers, because almost all of the other ones that we talked about, you need to take a very positive act to set up. You need to sign a contract for a contractual joint venture. You need to incorporate a company. You have to go and take a form and send it to company's house. And there's a real process. You know what you're doing when you're doing it. General partnerships sit in a slightly odd area in that you can have created a partnership without knowing that you've created a partnership. Because as a matter of law, if you're carrying on business together with a view to profit, then there's a chance, and I'm afraid it's always incredibly fact specific, but there's a chance that you may have set up a partnership. And so it's a bit tricky because what we always sort of say with these things is you just have to be aware of that, because it means that you can make sure you're taking steps early on to put the right structure in place, rather than find down the line that somebody might be trying to argue that a partnership has been created inadvertently. The reason why it's very important around a partnership having been created or not created is that in a partnership, each of the partners are personally liable. A partnership isn't a separate legal entity. The partners act in their own names. So we've got that same issue that we had for contractual collaboration where you are personally liable. But worse than that, in a partnership, a partner can bind each of the other partners. So to take an example close to our heart, a lot of law firms used to be general partnerships. And if one partner went off and gave some advice that was negligent, the whole partnership was liable. Each and all of them stood behind one another as partners. That, of course, is absolutely fine. It's a family partnership arrangement because there's a family relationship. Everybody's working towards the same goals. Everyone's got a sort of level of trust and confidence in one another that everyone's going to act in a certain way. For a partnership where you're dealing with third parties, particularly if you're not aware of it, particularly if you enter into it by accident, you won't have the long-form partnership agreement. You won't have agreed with one another what the structure is and how it's going to work. And so there is a risk, a much greater risk, that somebody might do something and you, as a fellow partner, would be personally liable for those actions. So for that reason, for this sort of collaborative work where you're dealing with third parties, a partnership is unlikely to be the most appropriate. A limited liability partnership, in some ways, it's very similar to a company. You have to incorporate it with company's house. It is a separate legal entity, so it can contract in its own right. So you avoid some of the disadvantages of a general partnership, and it is very much akin to an alternative option to a company. We tend to find that the key driver for people entering into limited liability partnerships, and it's a similar position for general partnerships, is that they are tax transparent. So the profits of the partnership, the profits of the LLP are treated as if they're profits in the hands of the individuals, and there can be circumstances where that is much more desirable than having profits sit in a limited company. It's my experience over the last few years, LLPs are a lot less popular. Perhaps in part due to the record low corporation tax rates, which have meant companies are sort of seen as being preferable, but also I think some of the tax drivers are just no longer there. So we just wanted to mention them, but we suspect that for a lot of reasons these may not be what you're looking for.
Right. So just to stress the sort of the flexibility and the informality coupled with potential tax benefits associated with a general partnership, a fine for a sort of family farming partnership, that's a family arrangement or arrangement between a number of trusted individuals, but for the broader, wider collaborative arrangement, they're not ideal.
No, that's right. I don't want to set any hairs running. Your fine partnerships, I'm sure, are all fine, but it is when you have got this arm's length arrangement, they do have to be heavily structured to ensure that there aren't going to be any issues. So I think that takes us to our final slide, which is just a sort of high-level summary of the risks and challenges. So just to rattle through these very quickly, so things to think about: finance and future funding. Where do you see this coming from? Is it coming from the private sector? Are you expecting a grant? If it's coming from a granting body, what do you need to do? What will they be looking for? How is it best for you to structure yourself now so that you are positioned well to be able to take advantage of that? What are the, if there is a grant, under what circumstances might it be repayable? Just things to be thinking about quite early on. Enforcing agreements can put a strain on relationship. I'm afraid this is unavoidable. Every single structure that we've discussed has some sort of agreement or arrangement underpinning it. But what the point here I'd make here is, if you can be upfront with one another, if on day one you can sit around a table and say, we all agree, we're all going in this direction, we're pulling in the same way to accomplish this goal, and this is how we're going to do it, then enforcing the agreement in the future, it's less difficult, because it's just saying, well, no, when we had that discussion, this is what we're doing. The biggest issue we have is where people, they might take a document that somebody else has used that isn't appropriate for them, they're just going to go ahead with it, and then they're actually not aligned, they're pulling in slightly different directions with slightly different pressures, and the result of that is that then you're looking at a contract that wasn't really fit for purpose because people hadn't considered it as they necessarily should. Maintenance of assets, particularly if you've got land or property involved in any of these structures. If there's land going in, who's going to own it? Who's going to manage it? Who's going to insure it? Who's going to maintain it? Things like this just need to be thought about. Where's the responsibility? Where's the risk lying between everyone? Landlord and tenant issues. If you've got neighbouring parcels of land and they've got different tenure, how are you going to reconcile that with the different periods? Again, just high level, how does that work? Disputes or deadlocks, what happens if you can't agree? What happens if your direction changes? Well, one, if you have a clear conversation up front, you hopefully won't get there. But two, if you've built in a structure that says if there's a problem, this is how we do it, then you've got a roadmap, you've got a way forward. Hopefully, you can go after a trusted third party and they can say, you should do this, you should do that. None of us want to be getting to the courts, none of us want to ever be litigating over any of these contracts. And there's ways of building this in to sort of avoid that. And my very final point, tax advice. Tristram made the point at the very beginning. Almost all of these structures, there will be a very high degree of tax driver behind which is the best route. So taking tax advice early saves so much trouble. Tristram and I both have had a number of matters where somebody's done something, they take tax advice after the fact, and unraveling it is expensive, perhaps doesn't deliver the same tax advantages that they were hoping in the first place, and causes more trouble than it was worth. Now, I think we might have been running a minute or two over, so I think we'll pause there. Well,
Edward and Tristram, thank you. That was an absolute tour de force. So if I could ask Susan Trining to join us. The Q&A button is at the bottom of your screen, should you wish to ask a question. I'm going to hold fire on one question that has already been asked, and I'm going to ask my own, which gives Edward a chance to catch his breath. And I'm going to ask Susan, and then I'll come back to a question from James. Susan, what do you think is the extent for the market for environmental delivery? And do you think this market is accessible to everyone?
Thanks, Mark. That is the $1 million question, or perhaps the £1 billion question. If you look at the big picture, then there's potentially a lot of funding available. Even just looking at the current agriculture budget of 2.4 billion in England, and similar, obviously not the same quantum, but in Wales, there's most of that is going to be transferring into the new environmental land management scheme. The discussion about the proportion that will go into the different schemes there is still to be agreed, but there will be significant funding around. It'll be in the region, the top end of the near to the £2 billion per year. There's also a report from the Green Finance Institute last year that highlighted that there is a funding gap between what the government targets look to achieve and what the public funding is, of in the region of £21 billion over 10 years, so another £2 billion a year in England, and £5 billion over 10 years, or £500 million in Wales. So there's a significant funding. The government has committed to try to find at least £500 billion per year by 2027 and £1 billion per year by 2030. So there is the expectation that there will be funding. There's lots of things driving this. There's the nature-related financial disclosures. There's already climate-related financial disclosures that are looking to make big business take nature and climate very seriously. And many are already doing that and looking at opportunities for where they can mitigate their damage that they do. Biodiversity net gain, which is the legal one, I think predictions vary about how much that might be, but they could be in the region of 5,000 hectares a year required in biodiversity net gain. So the market is quite significant. Whether it's available to everybody, that is a question. Biodiversity net gain, there's the mitigation hierarchy that means it tends to be close to the development sites, but it doesn't have to be there. Other areas, I think a lot will depend, and the reason we're talking about collaboration, I think a lot will depend on how you can sell yourself. And I think operating in a collaborative unit with others may well be a way of selling what you've got and looking at these bigger projects, more exciting, ambitious environmental projects that could capture the imagination of some of the private sector funding.
So, Susan, thank you. Yes, an opportune moment with lots to go at. So I'm going to come to James Shepherd's question. He's from Knight Frank. It's the $50 million question, because he asks Ames, Edward and Tristram, out of all the options, which agreement do Charles Russell Speechlys envisage being the favoured vehicle for delivering environmental projects, including BNG and carbon projects?
Anyway, we're talking specifically in the context of collaboration, so we've got multiple parties coming together to try and to deliver this. If it doesn't sound too loyally, it's rather going to come down to the facts of the individual matter, because you have two elements to consider. One is the land ownership, and the other is the collaboration structure. So if you're looking at potentially 3, 4, 5, whatever it is, landowners coming together to deliver, they'll sell BNG credits. The question's got to be, at the end of the scheme, what is going to happen to the land? So do you have a situation where everything goes into the structure, the ownership of land goes into the structure, and then, as we talked about, a company for many reasons might look an attractive proposition, but then you've got to think about what happens at the end of this. How do we get land out of the company? Do we want land to come out of the company, or are we going to do we envisage the land remaining in the company forever and a day, and there's going to be another use for it in the future? Or do we have we set up a new structure, could be a company, and then the land is then leased to the company on a sufficiently long lease with sufficient control by the company over that land to be able to deliver under the relevant scheme. I don't know, Edward, if you have anything to chip into that.
Well, I'm going to cut in on you, because there's a specific extra question to try and target your thoughts from Ed Cooper, who's given a specific example of 5 farmers, each paying biodiversity net gain on 20 hectares of land, with a 30-year contract with one buyer of biodiversity units from all the farms in the cluster. So how do you structure that with 5 wanting to be involved? They don't want to sell their land, they want to sell the credit, but they want to keep control and do it collectively.
So that comes back to having one point of contact. So as I went through the options, having the separate legal entity that can contract. So if you're not going to, presumably, as you said, the 5 farmers are not going to want to give up the ownership of their land. So you're then looking at a structure where you have that legal entity that will then be able to control the land sufficiently to be able to enter into the contracts. In that case, subject to exactly what the situation is on the ground, legal ownership and tax advice. I think there's enough caveats. You're probably looking at a structure where you are leasing land to that separate entity. As I said, mentioned company several times, probably for various reasons a company provides some of the best advantages to be able to then control the land, then enter into the contracts with the buyer.
Yeah, Trish, I think that's probably right here. I mean, a number of the different structures that I was going through, that there is an element of the community benefit being the main focus, whereas the question here from Ed, I suspect it sounds very much as though the idea would be to generate a profit for each of those shareholders. And so with that in mind, I think we've certainly got the sort of community benefit society off the table. It possibly is a community interest company, but I'm not sure why there would be any key driver to want to do that in this particular situation. So to my mind, and subject to being guided by the tax guys, it feels like it's a limited liability company. Now, whether it's a company that's limited by shares or guarantee will depend on circumstances. But I feel that particular example, that's probably where it's going to sit, subject to the specifics.
I suppose actually, if you have a company then, and you have the lease that is then linked to the longevity of the scheme, and you're not putting capital in, at the end of the project, you then you have the ability to wind up the company more easily than if you've been putting capital into it. As in
No, that's helpful. I'm going to bring Susan in next, but I'm just going to finish off on that question by just adding to it. I happen to know that the Environmental Farmers Group, which is a much bigger cluster than the one noted by Ed, they happen to have formed a company limited by guarantee. Now, I'm just interested, what's the distinction between a company limited by shares and a company limited by guarantee in a nutshell?
In a nutshell, companies limited by guarantee tend to be used where, I mean, the simple answer is that there's no real distinction, and you can't tell by looking at it. It's saying limited or LTD at the end. Companies limited by guarantee tend to be used where there's less of a focus on profit. As an underlying concept, if it's company limited by shares, then you put money into the company to buy shares and you get the shares. A company limited by guarantee, you as an individual don't put any money in, but you guarantee up to a certain level. So you might say, I guarantee £100, £1,000, whatever it is. And so even only if the company requires it, will you contribute your money. So it's a bit different. You put your money in at the end, you never need it. And most guarantee companies never call for these things.
No, that's really, really helpful. Now, I've got a question for Susan from Chelsea Fuge, who says, I'd be interested to know how you would say landholders working together to provide environmental services to markets as a collective rather than as individuals.
Yeah, I mean, I think that there is an option to work as individuals. So you're working, I suppose, as a coordinated way. So you could have a project that you're delivering where you've got adjacent land and you all agree to do your own bit, but you do a separate countryside stewardship scheme or other funding route. So you could do it that way. I think the other way would be the collaborative, which is what we're talking about today, where you're actually deciding that you're going to for that land management, that you might have a plan for what you're going to be doing. It might be putting into woodland or a wetland. It takes land from across all 5 holdings, and you would put in a plan together of what you're going to be doing, work that through, and then look for funding. So that could be going to, could be biodiversity net gain. It could be the environmental land management landscape recovery scheme, depending on the size and the makeup of what you're wanting to do. And there are other potential sources of funding as well. And then I think it's a case of looking at how you would, the reason we're bringing the legal structures in today is because if you were going to do it in that collaborative way, and for some of these funding routes, you can only do it in a collaborative way. So, for example, the Landscape Recovery Scheme, DEFRA is only wanting one application, and there needs to be the legal structure under it in order to access the funding. And that may well be the case for other funding routes as well. So, you know, even if you were going to go for somebody who was looking, you know, a company who was looking to do some corporate social responsibility or ESG type investment in nature, they may well want to just have one contract with one entity rather than a contract with 5 different entities with lots of different management issues. So I think it is about coming together initially, about have you got a plan that is more than, you know, bigger than the sum of its parts, and then looking at the legal structures that might suit what you're wanting to do and how you then might access, and that may depend on how you might want to access funding.
Yeah, no, Susan, thank you. I'm fully aware time's very short. I'm going to try and squeeze in something that involves landlord tenant for Tristram and Edward. And Alice Lampard asks, how would you approach a collaboration to provide enhanced BNG to include multiple land managers, at least one of whom is a tenant or landlord, and then somebody else is totally anonymous who's interested in this landlord-tenant relationship as well?
I mean, there are a number of ways of achieving that. One would be, I mean, there's no reason why a landlord and tenant and other landowners can't enter into one of the structures we talked about. There's no reason why the land couldn't all be pooled and parcelled up, could be pooled to be made available to, for instance, a company, and the tenant and landlord and other landowners could all be shareholders of that company. If I think one of the examples was specifically, one of the questions was specifically about a landlord and tenant. So by that I assume you mean you've got a landlord-tenant situation, and both landlord and tenant want to take advantage of you want to sell BNG units, whatever it is, rather than involving other landowners. So that is something that could be catered for within the tenancy agreement itself, whether you have one or the other that effectively acts as agent for the purpose of entering the scheme, and there being a mechanism within the tenancy agreement that sets out how both parties can benefit from any payments that come from that. So I hope that answers the question, but yes, you can either have one, deal with it in the tenancy agreement, 2, it can be wrapped up in one of the corporate structures we've talked about.
Yeah, no, that's extremely helpful. Now, we're actually, because time has almost gone out, we're going to have to close it. There was an earlier question from Anne Wilcox about the facilitation fund, which we'll take offline, but we're, as the CLA, very supportive of the facilitation fund. And the other questions that we've got will aim to come back to you. So it only remains for me to thank everybody for joining us. It's an extremely exciting emerging area with lots of opportunities. And we're very keen to support members in understanding this. Please get in touch. There will be a guidance note on the website for you to look at. So please do contact the website, look at that. We've got a series of webinars. Do please come to the Rural Business Conference, which is up on the screen on the 1st of December. So I'll finally thank Susan for her contribution and all the work she does behind the scenes, and particularly to Edward and Tristram from Charles Russell Speakeasies for their input into our guidance note and this clear and thoughtful presentation on the legal structures. So I hope you found it useful today, and thank you very, very much indeed for your participation. Thank you.